Welcome. Today, we've got a really cool opportunity to talk a little bit about background screening and legal compliance. My name is Brian McCaman. I'm with Alliance Background, and I'm joined today by a good friend of mine, Chris Cavaliere of Shumaker, Loop, and Kendrick. And we're going to have some fun discussing the ins and outs and nuances of background checks. So, Chris, you ready to get started?
I think I am. I'm always happy to talk about the wonderful world of background checks. So
Awesome.
Let's get after it.
Awesome. Let's get after it. So first and foremost, right, everybody's running background checks in some way, shape, form, capacity. Why? Like, what is the real reason we're running these?
Yeah, I mean, so you'd be surprised actually. Some companies do not run them, and we'll get to the risks of not doing it in a second. But there are some. I would say there are 3 or 4 main reasons why my clients, as an employment lawyer, typically run background checks. The first is to make sure you're getting the person that is applying to you, right? That making sure that what they're telling you in the application is true. So we're making sure that their educational history is correct, that their job history is correct. We want to make sure that this person is honest. If they're lying to us in their application, probably not a good indication that this is going to be a reliable employee moving forward. When we're talking about criminal history, and we're going to get to that in a second, oftentimes we will ask about conviction history in Florida, and we're only going to be talking about Florida law.
Right, of course.
A lot of times, if someone lies to you about their criminal history, and if your application has the right language in there that we can reject you for lying to us, well then guess what? If the person lies to us about their criminal history and tells us, oh, I was never convicted of anything, and we run a background check, find out that they did, well then we're not getting rid of them because of the criminal history, which can be a little risky, and we'll talk about that in a little bit, but we're getting rid of them because they lied to us. So one of the reasons why you do a background check is to verify that what the person's telling us is true, and you can avoid getting into the sort of murky ground of, well, did we get rid of this person because of their criminal history? No, we got rid of you because he lied to us. Another reason is we want to protect our employees, right? If we do a background check and find out that somebody was convicted of pulling a gun on a coworker 5 years ago, this is something that we might want to consider before we decide to bring this person on to our company. Same thing with protecting against theft of company property, theft from coworkers. If you find out that someone was convicted of theft recently, this might not be somebody that we want to put in a money handling position. And finally, there's always the requirements. Some companies are required by contract. Some state contractors, some federal contractors are literally required by the contract that they have with the federal government or the state to run a background check. Some industries require background checks, childcare, healthcare. So those are sort of the big 3 or 4 reasons why companies would want to run a background check.
Those are some pretty significant reasons. So I appreciate that you were able to level set and give us that understanding. All too often, we go through the motions and never really question, why are we doing this? So it's important to have that foundation. You mentioned a little bit about some of the things that we're looking for in a background check of a potential employee, but can you elaborate a little bit more on what some of those different components could be?
Yeah, sure. I mentioned employment history, education history. Those are sort of the typical ones that we think of when we think of background checks. Criminal history is a big one too. And again, I'll emphasize that when it comes to criminal history, outside of the state of Florida, several states have very specific rules about when you can even ask about, when you can even look into criminal history. We're not talking about other states right now. In Florida, as of now, you can look into criminal history at the time of the application. That's a big one in Florida. We're going to look into somebody's criminal convictions, right? And we're going to get into the murky waters when dealing with criminal history, I think, a little bit later in this session. So employment history, education history, criminal history. If someone's going to be operating a vehicle in the course of their employment, if they're going to be a driver for you, well, then obviously we want to know a little bit about their driving history, right? That's going to be something that we're looking for, that we're screening for. And again, just like some industries might be required to do background checks, again, those industries might actually tell you what you need to be looking for in that background. Couple things that I think we need to be careful of when we are looking into these things in background checks is credit reports and social media. So when we're talking about credit reports, the EEOC, and that's the federal agency in charge of administering discrimination laws and other similar laws, they're all over this. And they say, listen, if you're going to be asking for an employee's credit report, this stuff is pretty protected, right? So the EEOC says you better have a pretty darn good reason for asking for someone's credit report. You basically have to have a compelling reason that the person is going to be handling money, or that they have to have some sort of a financial responsibility in the job that they're applying for. So that's something that typically companies might look into, but if you're going to look into it, you sort of have to just keep in your mind, maybe I want to be a little bit careful about this before I do it. Social media is something that a lot of companies will do, whether it's through a company like yours, Brian, Alliance, or whether they do it themselves. A lot of companies will sometimes do a background check involving, let me take a look at this applicant's social media account. Let's see what kind of person that we're dealing with here. This is another tricky area, and to be honest with you, I generally will advise my clients to just avoid looking at their applicant's social media accounts, because what that does is it might give you information about the applicant that is protected that you might not have otherwise known. Maybe you look at their social media account and you realize, oh, this person's a minority, or this person is religious in some way. And we're sort of just getting into the murky ground of putting ourselves at greater risk the more we know about those sorts of protected types of information. So I just generally recommend, when it comes to social media, just don't do it. I don't see a whole lot of benefit to it, but I hope that gives you a good idea of what are the typical types of things that companies look at.
It does. You know, it's interesting you mentioned social media. So much of that information is publicly available. You don't need to necessarily run a search. I'm curious, in your experience, if someone does have a private social media, perhaps their activity on Instagram or Facebook is labeled private, is there ever a business reason that they could force someone or compel someone to divulge that information? And I guess what I'm getting at is, what if someone does have a private social media account? You run that background check and you are looking for something, but it's private and nothing's easily available. Can they be forced to turn that information over?
I guess it would just depend on the situation, right? So maybe it's hard to imagine in the application context. If somebody is just applying for employment, it's difficult to think of a reason why an employer would truly need to see something in that person's social media. When the person has become an employee, that's a totally different story, because maybe the employee says, I need to take FMLA leave, I need to take medical leave because I'm really, really sick. And it comes to the employer's attention that, hey, he's got some friends and they saw on his social media account that he was out fishing or maybe golfing during his medical leave when he said that he was so sick he couldn't come into work. Maybe at that time there's a reason for the employer to okay, I heard that there was something on your social media account. Is that true? But outside of that, in the application context, I would just say, just be really, really careful and just generally try to avoid it if you can.
It's outstanding. You know, what, as we get into why and more of the why run them, what's your opinions and your views on the legal consequences of failing to run one? We've covered some of the reasons why you would. What does a company stand to lose, or what would be some of the disadvantages of not running a check on somebody?
Yep. I mean, in my experience, I think most of, at least my clients, do run background checks. I haven't seen the statistics. I would imagine, just like you assumed at the top of this session, that most companies probably do run background checks. But I have seen a lot of occasions where companies, for a variety of reasons, choose not to do it, whether it's cost or this idea that they're opening themselves up to liability by doing it, or even worse, by doing it in the wrong way. And we're going to get that in a second. But there are some serious risks by not running a background check. And really the primary risk I'm talking about here is what we call a negligent hiring claim. What does that mean? It means you brought somebody on who might have been dangerous or might have had a history of theft or embezzlement or something like that. And you failed to run a background check that would have told you that this person could likely have done the thing that they wound up doing. So just to give you some examples, you hire let's say a maintenance person, a janitor, and they wind up being accused of sexually assaulting one of your other employees. And you didn't run a background check on this person. And it turns out that if you had run a background check on this person, you might have realized that this person was convicted of sexual assault 10 years ago. He just got out of prison 2 years ago. And here you've hired a convicted felon with a history of sexual assault. You got some problems on your hands, right? In the theft context, maybe an employee that you bring on is accused of stealing from a coworker. And if you had run a background check on this person, you would have realized that this person was convicted of doing the same thing, or even just theft in general, a couple years ago. And again, as we're going to talk about, I think in a second, you can't just reject an applicant just because they've been convicted of any crime. But there are situations where you can, and under these situations, you run a risk of, when you don't run a background check, and if that person winds up hurting an employee or stealing from an employee or damaging their property, you're opened up to this negligent hiring claim, where the person who gets hurt or gets stolen from can sue you, the company, and say, you were at fault. You didn't run the background check. I've been harmed from it, and now you're going to pay me all of my damages and all of my pain and suffering. These cases can be super expensive. I think I saw one statistic that the normal settlement is around $1 million. I can't personally verify that. I can attest that has been consistent with my experience. But these can be super expensive cases. They're often very emotional cases, and they're just bad publicity for the company.
That makes complete sense. You can avoid all of that with just such a little step.
Yeah.
So we've talked about now why run them, some of the things to look for. Let's talk about permissions a bit. What's the level of permission needed in order to run one of these on someone who's applying for a job?
Yeah. First of all, I generally recommend, no matter if you're doing the background check yourself or if you're using a vendor like Alliance to do it for you, I always recommend that you get an authorization to do it beforehand. But to be absolutely clear, when you are using a company like yours, like Alliance, to run a background check, then you have to get the person's permission. By law, you're required to do it. And you're required to do it in a super specific way. I think we'll get to that in a second. But there's no way around it, because there's a federal statute. It's called the Fair Credit Reporting Act. I might call it the FCRA here. And what it says is that if you're an employer and if you use an outside company, like Alliance, to run a background check, that outside company is referred to as a consumer reporting agency. As soon as you use a consumer reporting agency to do a background check for employment purposes, then you are obtaining what the statute calls a consumer report. And when you do that, you have to follow all of these requirements. One of those many requirements is you have to tell the applicant, hey, I'm going to get a background check on you. And you have to get that applicant to consent to do that. So absolutely, I always recommend it. But if you're using an outside company to do the background check for you, you absolutely have to get the person's consent beforehand.
And is it safe to follow the train of thought that you're using a company like Alliance Background, you submit that authorization to the person who's applying for the job? If they say no, where does that start to alter the obligations of the company who's looking into potentially hiring this person?
Yeah, the FCRA, the Fair Credit Reporting Act, straight up says that you cannot obtain that consumer report, that background check, until you get that person's authorization. So if the person either doesn't say yes or no, or if the person says no, then you can't obtain that background check. So you really do have to get that person to sign and return that form before you even begin the background check process.
As we're talking about authorizations, let's elaborate a little bit more on some of that paperwork. Are there particular forms? What's some of the makeup of those forms? How do we keep all of this stuff straight? Can you elaborate a bit on what some of that paperwork looks like and what people need to be thinking about as they're either crafting their own forms or receiving sample forms from consumer reporting agencies, as they're building this out?
Yep. Well, first of all, like I said before, I'm only going to be addressing federal law, Florida law, because when it comes to this subject, background checks, a lot of states have their own background check laws. Luckily in Florida, we sort of don't have that many specific requirements of our own. We just defer to whatever the Federal Fair Credit Reporting Act requires. But when you're talking about Florida, you really have to have two forms or possibly one form. The first thing that you need to provide the applicant is what we'll call the disclosure. Okay, what is that? That's literally disclosing to the applicant, we are going to be obtaining a consumer report from you or an investigative consumer report. I'll get to what that means in a second, for employment purposes. Just telling them this is what we're planning on doing. Okay, that's step one, the disclosure. And you can put that on your own separate form without the authorization. We'll get to that in a second. The second thing that you need is the authorization. And that's just as important, if not more important. That's where you say to the applicant, by signing below, you're authorizing us or consenting to us running a background check on you. Those are the two big ones. If you are having a consumer reporting agency like yours, like Liens, reach out to people and do personal interviews instead of just reviewing public records, if they're actually doing personal interviews, then the federal statute that I've been talking about, the FCRA, considers that to be a, quote, investigative consumer report. And in that case, in addition to giving the applicant the disclosure and the authorization that we just talked about, you also have to give them a copy of a summary of their rights under that Federal Fair Credit Reporting Act. If you're not doing personal interviews, you don't have to do that at that point. But if personal interviews are being done by an outside vendor, then that's a third document that you need to give the applicant.
As we're thinking about these documents, I'd anticipate there's some pretty specific language that needs to be on these. Can you elaborate on some of the components that need to be on these forms? If there's issues with overcrowding on a form, explain to us a bit about some of those considerations as, again, companies look to build out their own authorization forms.
Yeah, I mean, and this is such an important question, Brian. I give talks about background checks a lot and using criminal history. And one of the things that I always take a step aside to really address the audience about is this particular topic. It's what to put in your disclosure and your authorization form. And the reason why is because under the Fair Credit Reporting Act, there's a very, very specific requirement that the disclosure you give to the employee or to the applicant, the disclosure needs to be on a document that consists of nothing but that federal disclosure. I'll call that the standalone document rule, just for an easy way of talking about it. And what the courts have found is that basically what that means is that disclosure form basically needs to be limited to just saying to the applicant that we are going to obtain a consumer report or an investigative consumer report about you for employment purposes. Here's the definition of a consumer report, or here's the definition of an investigative consumer report. What that does not allow you to do, and the courts are all over this, is I see a lot in my experience that a lot of companies will put state law notices or state law language on that federal disclosure form. For example, we're going to obtain a consumer report about you. Here's what a consumer report means. That's fine. If you're a resident of the state of Minnesota, check this box if you'd like a free copy of your consumer report. That's a no-no, because that is information that is extra. That is information that is something other than just the disclosure under federal law. That's a no-no, state law language. An almost bigger no-no, and maybe even a bigger no-no, is again something I see a lot of companies do, which is they will put waivers and releases on the federal disclosure form. So on the disclosure form, it might say, we're going to obtain a consumer report about you for employment purposes. You hereby waive and release us, the company, from any liability, from anything that could go wrong by running a background check. And as we're going to get to in a second, when it comes to the penalties for violating, courts have not only found that this is a no-no, they say that to do this, to put a waiver or a release on your disclosure form, amounts to a willful violation of the Federal Fair Credit Reporting Act, and it carries with it extra damages that we'll get to in a second. So one exception to this requirement, to the standalone document rule, is that, as we just talked about, that document can't have anything but the disclosure. The one exception is that you can put the authorization on that document, so long as the authorization doesn't overshadow the disclosure. So I can just say, in my experience, I've done it both ways for clients. I probably more often than not will put them both on the same form. You just have to make sure that the authorization is probably going to be fewer words than the disclosure. It might be a separate section. You don't want to mix them up so it's confusing. You have to be careful when you're doing it. So I recommend, maybe for my selfish purposes also, I always recommend you talk to an attorney whenever you're dealing with these forms, even if you get them from an outside vendor.
That makes complete sense. On a bit of a side note, I'm curious, in the forms that you've reviewed for your clients and potential clients, do you find that when you're making those material changes that they drafted those forms themselves, or did they try to incorporate legal advice, as they were creating them? I'm just curious where you see the majority of the errors or the challenges with those forms arise, if it was a DIY option or if they're just receiving bad information from someone.
Yeah, a lot of the times the company has drafted these themselves. I mean, this seems like a common sense issue, right? The problem is that when it comes to legal stuff, you kind of have to just throw common sense out the window. So a company, rightfully so, might think like, all I got to do is put on this disclosure, hey, I'm going to be running a background check against you. Is that cool? And here's some other information that I think you might be aware of if you live in California. Like, what am I doing wrong? So a lot of times, yeah, the company themselves will do that in good faith and under good spirit, not even realizing that they're violating the law. Other times, maybe they've received a form from a lesser background check company than yours. And I've seen mistakes from outside vendors, honestly. So you have to be really careful, and I just sort of generally will always recommend, no matter where you get the form from, you should always at least have an attorney spot check it for you.
That's sound advice. We've walked through now several of these different components: why screen, what to look for, how to receive the authorization. I'm curious on the flip side of it. We've done we're looking at doing all of this. What are some of the consequences of not? I mean, you shared some of the risks that, intuitively we know are not great, but walk us through some of the legal consequences of failing to perform or being as diligent as one should during this process.
Yeah. And by that, you mean like failing to do a compliant background check? Like
correct.
So the consequences are stiff, and this is why I spend so much time on this topic, is because a lot of plaintiff firms in the area are really targeting large companies whose background check forms might be less than perfect. And the reason why is because that Federal Fair Credit Reporting Act is so strict about what needs to be in these forms and what cannot be in these forms. So what are the consequences? Well, we talked about that there is what's considered a willful violation, right? So the Fair Credit Reporting Act sort of splits this into two. It says, look, if you've committed a willful violation of the Fair Credit Reporting Act, then the consequences are X and Y and Z. If you've committed a non-willful violation or a negligent violation, then the consequences are a little bit less. So let's talk about willful. We already talked about before that if you include a waiver or a release on that federal disclosure form, you're in trouble, not just because it's a no-no, but because courts have found that that automatically constitutes a willful violation. Whether you even knew that what you were doing or was wrong, courts have said that this is so obvious. This is the rationale behind these courts. This is so obvious, you should have known, and it was reckless for you to put that language in there. So what are the damages? Under a willful violation, every single bad background check that you run under the Fair Credit Reporting Act, every single form can be a violation of up to $1,000 automatically, regardless of what the plaintiff's damages are. On top of that, punitive damages are possible. These are damages that the court could assess against you just as a punishment for being so bad, for lack of a better way of putting it. And then the big one, because this is sort of a driver in a lot of these cases, is that you could pay attorney's fees and costs. Okay, so now it's one thing if you get hit by a claim from one person. Maybe those damages are limited, but that's not what we're seeing. And me personally, that's not what I'm seeing. We are seeing plaintiff firms, even in this area, Hillsborough County, Tampa Bay area, are filing class action lawsuits, or at least they're threatening class action lawsuits. And they're saying, we are bringing a lawsuit against you for every single background check that you've run in the last 2 years, which is the usual statute of limitations. So think about it. If you have 200,000 employees that you've run background checks on in the last 2 years, that's potentially up to $1,000 times 200,000 plus punitive damages plus attorney's fees. You know, I've seen cases settle for hundreds of thousands of dollars. I've heard of cases settling for millions of dollars. This is a very, very serious thing. And when you're talking about a negligent violation, the damages are a little bit less. They're still pretty serious. It's basically whatever the plaintiff's actual damages are. So if they can show the court, look, by not doing this background check correctly, I was harmed in some way, they would get their damages in that way, plus their attorney's fees and costs. So either way, the damages are extremely severe.
Yeah, it's easy to see when you start running some of those numbers what a class action lawsuit can do to a company and their liquidity and the future state of them. So it goes without saying that you should probably be running these. What about internal company policies? I mean, I know we've started to cover obviously why do this. Do you have any commentary around internal policies, standardization? How often those should be revised? Walk us through a bit of that.
Yeah. First of all, I absolutely 100% think that you as a company should have an internal policy about background checks. And I say that for a couple big reasons. Number one, you want to make sure that you're doing it in the right way. If you're trying to keep all this stuff in your head, in your memory. I mean, I'm a lawyer. I do employment law every day, and I sort of live and breathe this stuff. And I still have a difficult time keeping up with the changes in the law and all of the details and nuances when it comes to these forms that we were just talking about. So having an internal written policy it helps you ensure that you're doing it in the right way every time. Number two, having an internal policy makes sure that you're doing it in the same way across the board, that you're not cherry picking and saying, well, I'm going to do it the right way for John Doe, but I'm going to cut some corners for Jane Doe. Well, guess what happens there? Now you've opened yourself up to a discrimination claim from Jane Doe because, you sort of administered it in a different way for her than you did for John. So it ensures consistency. It ensures that you're complying. It doesn't really help if you have a great policy and you don't give it to the people who are going to be administering, right? So you can have a beautiful policy, but if you don't disseminate and train the employees who are going to be handling the background check process on it, it's no good.
That makes complete sense. Before we start to wrap this up, what about bankruptcies, liens, and judgments? What are your thoughts around a report of that nature versus, say, a credit report? We know that there's a lot of criteria from the FCRA about what we can and cannot look at, and why. I'm curious to get your thoughts on those two components as accurate indicators, and if you have a compliance preference, one direction or another, and explain that rationale.
Sure. I don't necessarily have a compliance preference one way or the other, and the reason why is that just like if you're having an outside vendor like Alliance look into bankruptcies, liens, and judgments, what that is doing is you're getting a consumer report under the Fair Credit Reporting Act. A credit report is also a consumer report. So all of these things that we're talking about, bankruptcies, liens, and judgments, and credit reports, they all qualify as consumer reports if you're having an outside vendor get it for you. So you're still required to comply with the Fair Credit Reporting Act. The one wrinkle I'll put in there is that when you start getting into the realm of credit reports, like I hit on before, you're on murkier ground because you have to have a compelling reason, according to the EEOC, to run a credit report. Also, the Fair Credit Reporting Act requires you to give more information to the applicant. Specifically, for example, you have to actually give them what their credit score was that you discovered, to give them an opportunity to dispute it and say, hey, you got the wrong person. That can't be me. I've got 780 credit score. This person's got 560. This can't be me, right? But from a compliance perspective, no huge difference. I would just say that credit reports are riskier, and you have to have a really good reason to do them, and there are additional requirements when running.
What happens if the applicant that you've run a background check on fails? So Chris is going to elaborate a bit for us on what does that entire process look like? What do we need to be concerned about? What are some of the thoughts and documents that need to be involved in all of this? So Chris, I'll turn it over to you to share your legal insights and be able to help everybody.
Yeah. And this area, Brian, is one that a lot of companies get tripped up on because there are a lot of trap doors. So let me talk about some of the first trap doors that you can mistakenly fall through. First of all, let's talk about criminal history. Let's say you run a background check and you see something in the person's criminal history that's not good. One thing that the EEOC has been repeatedly clear on, well, a couple things when it comes to criminal history, is number one, you cannot reject an applicant just because of the fact that they've been arrested before. You can never do that, okay? So arrests are a no-no. Almost across the board. There are very limited exceptions, but they're so narrow I won't even get into it right now. Even when it comes to convictions, though, and remember, when I say conviction, I really mean conviction. Some people think that just because someone pled guilty or no contest to a crime means that they've been convicted. I can tell you, I was a criminal prosecutor before I became an employment lawyer. And I can tell you that you can plead guilty to a crime and not be convicted for it. How the heck does that happen? Well, the judge might decide to do what's called a withhold of adjudication. Some people might recognize that in doing background checks. They'll see a withhold and they'll just not understand what it means, and they'll assume it's a conviction and they'll reject the applicant based on that. That's also a no-no. The EEOC has also said, even when it comes to convictions, you have to be careful. You can't just reject an applicant just because they've been convicted of a crime. The EEOC says we've got to look into some factors. What are those factors? What was the crime, right? How serious was this? Are we talking about passing a worthless check, 20 years ago? The EEOC probably would not be all that happy about the fact that you reject an applicant because they were convicted of bouncing a check. Maybe if they are going to be handling money, and if it was very recently, and maybe if they have several of them in their past, and you're starting to tip the scales a little bit. But you get the point. You have to first ask yourself, what is the crime that they were convicted of? Number two, when did it happen? Or even more so, if they were put in jail or prison, when did they get out? If someone was convicted of even a more serious offense, if someone was convicted of, let's say, grand theft 30 years ago, and has had a spotless record since then, this would be a risky reason to reject this person for employment. Okay. Now, if they had committed grand theft 5 years ago, now we're starting to tip the scales in the other direction, especially since the third factor that the EEOC wants you to look at is, what is the job that this person's applying to, and does the conviction have anything to do with being concerned about the job that they're going to be handling? So let's take the grand theft example. If the person who is convicted of grand theft 5 years ago is going to be working in the back of the house, maybe on an assembly line, not handling any money, maybe we're not all that concerned about the theft conviction. But if the person's going to be a cashier or in some other money handling role, then you probably have more cause to say this person's just not going to be right for the position. And even then, we kind of have to consider, are there other positions that this person could potentially be qualified for, regardless of this conviction? So you got to be really, really careful based on criminal history. A lot of companies just want to say, I don't want any convicted felons working here, period. Now, it might be the case that you're required under some industry regulation or by some state or federal contract not to employ convicted felons. That's one thing. But if you're not under some requirement like that, we have to be very careful and follow those guidelines. Credit history. We talked about this during our last session. Be careful here. If you're running a credit report and if we're going to reject someone based on their credit history, remember, we have to have a compelling reason for why the credit report is necessary based on the job. So those are some of the initial trapdoors of things that we should keep in our mind. You also mentioned documents that should be had when you're rejecting an applicant. And again, if you're using an outside company like yours, like Alliance, to run a background check, like we said in the last session, you're required to comply with that federal statute called the Fair Credit Reporting Act. And what that statute says is that when you're going to reject someone, either completely or even in part, based on something that you see in their background check that was run for you by an outside company, you have to give that applicant notice before you reject them. We call that a pre-adverse notice. What does that do? It does several things. It notifies the person, hey, we saw something in your consumer report or your investigative consumer report, background check, that we don't like. We're thinking about taking adverse action against you, rejecting you for employment, right? We have to provide them with a copy of the consumer report, of the background check. We have to give them the name, the address, the telephone number of the company who ran the background check for them. So Alliance in your example. We also have to give them a copy of what's called a summary of rights under the Fair Credit Reporting Act. Very, very specific requirements. And the idea behind this is that we're giving the applicant an opportunity to say, hey, this is wrong. This is not me. You got the wrong guy or you got the wrong woman. You also have to give them at least a reasonable opportunity to dispute the accuracy of it. There's no specific time limit in the statute. We personally recommend waiting at least 5 business days just to be safe. By that time, it's a pretty reasonable time to say this person does not have any reason to dispute it, and then we can move on to step 2. What's step 2? It's the second document that you need to provide. If you've given them that 5-day period and they have not disputed it, or if they've disputed it in a way that's not satisfactory, then you send them what's called a post-adverse action letter. This is the letter saying, we have chosen to reject you. This second letter is the one where you've actually taken the adverse action. You've actually decided, okay, we are not bringing you on. And again, that letter has to have certain things in it. Again, the name, address, phone number of the background check vendor. You got to tell them, hey, the background check vendor, Alliance, was not the one who made this decision. So you know, they can't explain to you why we chose not to hire you, because they didn't make the decision. You got to let them know that they have a right to get a free copy of the background check. if they request it within a certain amount of time. And finally, you have to remind them that they have the right to dispute this by contacting the consumer reporting agency, the background check vendor. So I know this was a very long way of explaining it, and that's only because the Fair Credit Reporting Act has a lot of requirements, and you really need to make sure to follow them.
It sure does. And we appreciate you being able to walk us through those steps of what happens if an applicant does fail, knowing that there are so many steps we need to follow, rules that we need to adhere to. As we discussed previously, there's some pretty stiff penalties for failing to follow the Fair Credit Reporting Act properly. So it's critical that when something does happen, we follow those right steps. So, Chris, again, we're indebted to you. Thank you for your time. We'll go ahead and end it there, and look forward to doing this again.
Thanks, Brian. Next time.
Take care.